have this opportunity to try to advance these new developments in the legal research sphere. So I'm going to spend today in 2 sessions really giving you some background and some introductory material. So it's probably the most boring part of the material to come, but I want to give you a bit of a preview and an overview and explain to you how these various pieces from different disciplines and different styles fit together. Essentially what I think is driving my interest in doing this is that over the past while there have been a series of new models of legal scholarship that have emerged, and the hallmarks of those new models are that it's not law only, but it's a much more embracing interdisciplinary type of exercise, which requires that you learn as lawyers how to collaborate with people who have other training, other disciplines, other measures of authority in knowledge. And what is not only occurring in law, but in other disciplines as well, is a shift towards what is called evidence-based practice or evidence-based theory. And so this has been quite a long-established tradition in my other discipline. I'm both trained in law and in psychology, and neither one preceded the other. I did them together because I was very interested in how they interacted. And what I learned from the psychology side is that there's a very long tradition in what is called the scientist-practitioner model, which law did not have. And so psychology has had as one of its features that it regards itself as an evidence-based discipline. Nowadays we're seeing that other areas such as policing, for example, are also shifting to become entirely evidence-based. And so in the last year or two in Australia and internationally, there have been founded a number of new professional associations in the policing or law enforcement arena, such as Society for Evidence-Based Policing in Australia and New Zealand, to which I belong, and also there are many analog institutions in other parts of the world, and I guess India will participate in that. But law itself is, having to consider how does it relate to this evidence-based movement generally, and should law be focused less on doctrinal research and incorporate evidence-based practice and evidence-based policy and evidence-based developments and changes, or law reforms. And so really that's the nub of what I'm going to be focusing on, is how law might be able to engage with this new model and change the practice and the policy and the reform process by incorporating more of an evidence-based approach. And we'll unpack that carefully to see why it is that empirical legal research might matter today. So that will be one of the topics we'll talk about, and how it might then incorporate different social science perspectives, not only from psychology, but from other social science disciplines that are all part of this new collaboration. Although my examples are going to be drawing on the psychological end of it, because that's my other discipline. Naturally, we incorporate and encourage evidence-based work with other disciplines such as sociology, political science, economics, social work, etc. They're all undergoing the same sort of interface. And very key to this is some of the methods that are different, that are required if you're going to make the shift. So what is different about doing doctrinal type of research or legal research that is more evidence-based? And what other skills might need to be added to the traditional skills that lawyers receive because most typically, and certainly this was the case, when I went through law school, a lot of law students will say things like, I chose law, and one of the major reasons was I didn't really like math, I wasn't really interested in science, I wasn't interested in quantitative things, the things that I understand, our language and other parts of philosophy. I don't like those other sciencey oriented things, but now perhaps you need to embrace them, And I was no different when I started. I was a language arts teacher first of all, and I chose language-oriented things in my undergraduate degree because I didn't really like science and math and all of those quantitative things. They didn't excite me in the same way. However, over time, and especially when I started doing my joint degree in psychology and law, then, I learned more formal statistical approaches and methodologies, and, I realized numbers were quite so scary or quite so useless and so on. And so I've, gone on learning different techniques of analysis throughout my career. You can't learn them all in one little degree, and so part of what I hope that I can engage you in is the willingness to see this as a stepping stone to the kinds of things you might build on for years and years to come. So that in the last year or two, for example, I did a project where we really needed to use multi-level modeling. We'd never done it before in my kind of work, and I didn't even know quite how it worked when we started out. But, we figured it out, and we used it, and we gained some very good insights into some of our research by adding that technique. And it doesn't mean that you have to become a crack-shot statistician. It does mean that you need to kind of understand what somebody with those skills might be able to do in collaboration with you to answer specific kinds of tricky questions that are there that you otherwise are going to be hiding away from. So I've learned I don't have to be the multi-level modeler. I don't, I just need to be a good user of these kinds of statistics, and so don't be afraid if you've had that approach towards those sorts of methodologies. Right, so turning next to just a little bit more about an overview of the course content. I would say that formally what we're looking at are relationships between individuals and institutions, usually state ones, and in my case, focusing that through the perspective of what you will learn to understand is legal psychology, and I will help you define that. That means that we're also identifying risks to justice, because the major concern of law is how to implement justice. And so what are, from a psychological perspective, some of the erroneous assumptions in law that undermine the capacity to achieve justice. So we will be looking at particularly erroneous assumptions, if you're a psycholegal researcher, about human behavior, as well as some of the systemic issues that might arise. And one example is the role of unconscious biases in our decision-making, in our communication, in our behavior. So that would be a very typical sort of activity. We'll also be exploring different types of evidence-based approaches to try to manage all of those risks that are identified, and particularly to do that in conjunction with people who work in other disciplines with other skills to support what we see as necessary law reforms in light of those deficits in justice because of the wrong assumptions. We'll be looking at contributions that empirical legal studies can make to current legal issues. And so we will cover a wide range of topics, including police-community relations, investigative procedures, as well as traditional adjudicative procedures, through an adversarial type of trial, on through sentencing and corrections, as well as looking at some ADR types of issues, because there's an enormous growth towards citizen engagement with alternate forms of dispute resolution rather than traditional legal forms, because that gives them a different way to engage that is more self-empowering, where they have more control over the outcome. And so there's a lot of interest from a social justice standard these days in those types of legal options and procedures, and how do they fit into the bigger framework. So those will be addressed. But here's just sort of a general overview of some of the topics that we'll be addressing starting tomorrow. The sort of substantive topics will not be the focus today, but we will get to those to help unpack those various framework issues that I just outlined. So those will include some aspects of policing and investigations, especially investigative interviewing. Part of the psychological arena that fits into that is understanding more about memory processes and the role of memory and how memory is engaged in the legal setting and in legal processes. How the law has traditionally assessed credibility of witnesses in order to make judgments about factual disputes, and what the state of the art is on detection of deception. In other words, can you tell whether somebody is lying from their body language, or are the cues that you think you've read about really useful? Should you rely on them? Those sorts of questions. One of my favorite interests in looking at law and psychology and how they interface is in areas where psychology deals with things that are not so visible and tangible, and it has struck me that the law has traditionally ignored those factors or dealt with them much more poorly than it deals with things like broken bones, or car accidents, or other types of injuries that have very physical, tangible, visible components. So I have grappled a bit with some of the issues in how do you assess psychological injuries when they're invisible, and can the law do a better job, and what can psychology as a discipline offer that might enhance the way that the law is dealing with that issue. So that's what that means. I've done quite a bit of work on lawyers' judgments as opposed to judges' judgments or other legal players' judgments. And one of the areas there that we see as a fertile area of research is a body of psychological literature on overconfidence biases. So I was very interested in the extent to which they might impact how lawyers deal with their clients, how lawyers deal with the cases on their portfolios. So I'll talk a little bit about that, and I think that has civil as well as criminal implications. The obvious area for psychology law to intersect has to do with mental disorders. That's probably the most traditional area that you would expect me perhaps to be talking about, but I'm only giving it a fairly small space among all of the other topics, because I really regard my role here as to expand your vision of legal psychology beyond those kinds of traditional areas. But we will have a look at things like the insanity defense. What does the research show on how mental disorders should be shaped and in different legal settings? A series of issues that cut across both civil and criminal arenas have to do with children in the legal system, as well as families in the legal system and in the justice process. And, that might encompass a host of topics such as domestic violence, or child sexual assault, or custody disputes, and marital dissolution. And so we'll look at some of the psycholegal contributions on that topic too. And then towards the end of the course, we'll be focusing on sort of the end of the adjudicative system, because I've got things arranged a little bit from the investigative to the sentencing spectrum. And so we'll finish up by looking at factors that influence sentencing, particularly unconscious factors that drive sentencing decisions. And then we'll look at, the correctional management system. Is it really fitting for certain theories of punishment to lock people up, and how many should be locked up and for how long? And what is the most effective way for correction systems to function? So we can't solve all of these problems. All we're going to do is look at the thrust in evidence-based approaches that might help to change some of our thinking about the way the law has addressed those issues. So that's sort of a little preview of what is to come. What I did want to highlight is that it means that we'll be looking at multiple perspectives. So we're not looking at the law just from, you know, the opinions of a specific set of courts or high courts or so on in terms of interpretations of doctrines. We're looking at perspectives of many of the players who are stakeholders in the justice sector. And so that means we will be focusing on data collected from law enforcement officers, as well as litigants, witnesses, victims, the lawyers that I mentioned, and of course including the judges and the corrections officers, but also lay citizens' involvement and their views of justice is a growing area of concern because of the fact that the law is so expensive. And trials are expensive, and for lay people to resolve their legal disputes today, it's becoming increasingly difficult for them to gain access to justice through formal mechanisms. So there's a lot of interest in educating people about their legal rights and how to resolve issues in alternate measures or with assistance, and so their perspectives have become critical as well. Right, so what do I want from you in this course? Well, I would take note that some of the readings that you're going to be assigned, which come mostly, you know, from a book that I co-authored when I moved to Australia with a colleague called Legal Psychology in Australia, and so I apologize that many of the examples that you might read are going to be in that Australian context, but the law is placed in a context, and so it has to be contextualized, and so it's difficult to talk about these things outside of context. But your role is going to be to adapt those materials and provide us with examples from your context and from your community and from your law. And so what I will be looking for as we work through those different substantive areas is for examples that you're familiar with, or perhaps not today, but maybe you will research them and become more familiar with them in the next couple of weeks, so that we can see where there might be analogous examples to the Australian ones of Indian legislation or specific Indian cases that are illustrative, or specific procedures that are adopted in the structural aspects of Indian law, and also research done by contemporary Indian researchers in that host of disciplines that we're interested in, including psychology, criminology, sociology, social work, etc. So I'd like you to dig out some studies as well that might inform some of the issues that we're looking at and place them in your own context. So very much I'm hoping not only that you will be engaged in discussion and we'll have time for questions, and we'll give you some group exercises so that you're not just listening to me talk day on and day out. And specifically there'll be some group exercises today and in some of those days where we have slightly more time together, so that you're not just listening to a talking face. And in between, please be active and take these issues and use your research skills to see how you can adapt these materials and what they might mean in your context. And occasionally, I might also provide some multimedia for you to look at. I don't know that we'll have much time in the class. All right, so some of the key concepts and issues that we will be distinguishing that are really foundational for you to learn, so that by the end of this session and this course, you should really have new insights on just what is empirical research, what are empirical legal studies, forensic psychology versus clinical psychology versus legal psychology or criminal psychology. So, you know, I'll start out by just highlighting, for example, that when I have talked with lawyers in Australia, I've been quite shocked to realize that although we're often using the words empirical research in our discussions, people have very different understandings of what is meant by empirical research. And so I want to make sure that by the time we get through this, we are sharing more of a common understanding of those terms. For example, sometimes some of my psychology colleagues, when they use the word empirical, really mean only a quantitative study with statistical inferences. But in fact, empirical is also used by historians when they do a fully documented, historical paper that is well sourced with other references. That is a piece of empirical research. And if we confine the word empirical just to quantitative, we would be ignoring a very important movement in the research arena in the last few decades, where qualitative studies have moved into their own, including in psychology, which has tended to be quite a bastion, of statistically oriented experimental research. But now we're much more embracing of even thorough case studies, as well as qualitative studies. And so the word empirical really is, I think, best used to talk about rigorous methodologies. What we're not referring to is, sort of armchair speculations. We are looking for evidence. And there might, so if something is going to be really evidence-based, I think it's appropriate to use the word empirical. I want to make it clear that when I use the term, I'm not ruling out, for example, qualitative studies or rigorous case studies. I would regard those as empirical too. So for example, at the moment I have a PhD student who is a police officer who happens to live in Canada. Of course, we do long-distance supervision of our research graduates from my university, and he is doing a series of pieces that are really a large case study about a witness protection program. So his topic is witness protection programs, but the data source is really just intensive case studies focusing, on one particular set of instances surrounding a particular witness. And that will be a psychological empirical study. He happens to be a registered psychologist as well as a police officer. And so that's how his is structured, and it's clearly going to be an empirical piece of work. Okay. So are there any questions about empirical? What is and what isn't empirical?
So if it is empirical, is it necessary to be field work?
Is it necessary to
be doing work in the field, or is it like to be doing empirical, but it's maybe looking through a range of evidence-based? I mean, what is this? Because generally the way we use empirical is we use it as a contradistinction to doctrinal. And so how would you distinguish there?
Well, I think I would include a systemic literature review as a piece of empirical work. So for example, I just did a systemic literature review of children's memory in cases of child sexual abuse, and we looked at about 750 or so studies that were all examples of primary research, and we synthesized them as they applied to a particular problem of institutional child sexual abuse. And so that is an empirical literature review with all of those citations, but there's no primary field work or no primary data collection on our behalf, but included in empirical work. I mean, what we have are the underpinnings now of what might be called a meta-analysis. So a meta-analysis is a piece of empirical work where you don't go out and collect original data yourself in the field, but you use other people's data and you put it all together to try to see, if researcher A in one country and in one community was looking at a specific kind of phenomenon, and got certain results, and researcher B used a similar methodology and got maybe somewhat different results, maybe because their measurement scales were slightly different. What happens when you put all of those data together? You get a stronger idea about what are the true effects of the phenomenon. So a meta-analysis is a research tool that is derived from secondary analyses of other people's data, that is extremely rigorous. And all of us in the empirical field would say that if you're looking for a strong idea about the trends of any phenomenon, what you want to base your work on more than anything else is the results of a meta-analysis, because it condenses all of the effect sizes that might be just artifacts of different people's methodology, different participants that were accessible, different contexts, and it synthesizes them in a more global way. So it's a skill to do a meta-analysis, and you usually have to contact the researchers and get a copy of their data set, and then you figure out how to put it all together. So that would be a very important type of empirical research indeed to use to base your policies on. Much stronger than one individual study.
So you actually build on. And it basically does mean that possibly some of the skills that we bring into doctrinal work kinds of then feeds into the empirical work that other people have done and produces a third resource.
Yes, because the doctrinal work might be the source of the questions. And might be the source of the hypotheses that you're testing. So if you can use the doctrinal work as the springboard to generate the research questions that need to be validated with data. We'll try to work on a few examples. What I'll want you to do is to try to identify some empirical questions. So when I say what is an empirical question, as opposed to a non-empirical question, what do you think that means? An empirical question would be one that is susceptible of being answered by recourse to data that would help you to decide whether your theory has legs or not. So oftentimes in treatises that you see, including some that are produced by law reform associations, you see an enormous amount of effort by the lawyers to analyze all of the doctrinal research from multiple sources, put it together, to focus on what they think are the strengths and weaknesses of different positions. But oftentimes there may not be data available yet to test those propositions. So what the empirical researcher can do is look at those questions, go out and generate the data, or find the data that helps to address them. So for example, recently when I was looking at some law reform papers that were assessing the question of unfair prejudice in a set of trials, I had some research assistants who were assisting me, and I was trying to figure out what sort of theories there were of unfair prejudice. And one of my assistants came back and said, well, it's the matrix, the risk matrix. And I thought, well, that sounds very much like a sort of law and economics, maybe psychological risk theory. I just don't remember seeing any studies on that topic at all. So what is this risk matrix? And I said, go look at all the footnotes, dig out all the resources for that statement in the law reform policy document for me so that I can see what I'm missing. Maybe something, went by me and I missed that whole line of work. And we tracked it down, and he came back and he gave me all the sources, and we followed them all up, and lo and behold, we found it was just a discussion that had been documented between a highly qualified legal theorist and some other colleagues, in which they had postulated and speculated that in certain kinds of situations there would be unfair prejudice because people would be reducing the burden of proof in a criminal case in certain circumstances. But that's all it was speculation. It had not a single data point to inform it, and yet the legal policy had been changed and based on that discussion. So as a researcher, I would say that was an error on behalf of the Law Reform Commission, because I would not be persuaded as an empirical researcher by a discussion. No matter how knowledgeable, it's an empirical question that they were asking. They were saying, in a situation of, and in this particular one was about joint trials or separate trials, they were saying that when you have a defendant who is charged with multiple crimes and you join the crimes in a single trial in front of the judge, that the risk of unfair prejudice goes up, because when there are multiple instances, people will reduce the burden of proof, and instead of finding somebody guilty beyond reasonable doubt, they will adjust the burden of proof because there are multiple events. Well, that is a theory without any feet to support it, unless there are data showing that that is what people actually do. So what we were able to do in our study was to set up a situation where we compared people's burden of proof as it was applied in a single trial or a separate trial versus a joint trial, to see whether in fact they reduced the burden of proof and used a lower burden of proof in the joint or the separate trial. And what we discovered was that those theorists were completely wrong, and that in fact the more rigorous burden of proof was applied in the separate trial. They thought that it would be reduced in the joint trial. We found the burden of proof was 10% higher in the joint trial than in the separate trial. And so in fact, the fact finders were doing just the opposite of what had been assumed in the Law Reform Commission's document, based on a non-empirical statement. So I hope that sort of gives you a very concrete example of what is an empirical question and how you can go about answering it. You need to have the data to address it, to test it. So a lot of the work is testing the theories, testing the assumptions. That was an assumption that was made about how normal people might be reasoning, but it was an untested assumption.
So in effect, we are asking for informed legal reform, in the sense that there should be a database for any kind of proposition that you're making, and just kite flying would not be sufficient.
That's I think where certainly some of the field is moving. I think it's an area that is still somewhat controversial, but I think that there have been institutions that have supported empirical legal studies, such as the London School of Economics has had an empirical legal studies sector and faculty on board for a number of years. And they've been influential, and they've also looked at what are some of the barriers to adopting empirical legal studies as an approach to reform. So that's certainly a position, given my dual training, that I endorse and favor. And so, there might be areas for you to think about where that's not appropriate. That's one of the questions we should be thinking about. But yes, exactly, that is the argument that is being supported.
Professor, I just had a small concern regarding this empirical research. So is it possible that at some point when we are commencing an empirical research, it might be based on a hypothesis that we make, and over the course of research, in the empirical research, we find that somewhere that hypothesis changes, and how do we fit it into the entire research that you were doing altogether? That could be possible. Is that possible?
Sure. So, sometimes when you start out with a hypothesis that you want to test, if it's, you might have an idea about how it would turn out, but usually it takes more than one test to test it rigorously. So one study might not be the basis for solid law reform, depending on the study. So I think that the general view in science is that You need to have hypotheses tested in multiple ways. And yes, as you get answers, you might refine your hypotheses and they might change and modify. Because if your hypothesis is not supported at all, then you might need to change the direction of it, qualify it in some way based on the circumstances. And so what you might develop over a period of time is a full program of research that unpacks a certain problem or issue, and you have to be very patient. I mean, I think one of the things that lawyers struggle with is that they're used to working sort of independently in their own offices. You know, they get engrossed in a certain kind of problem. They look at the doctrinal issues. They don't have to talk to anyone else about it. They produce sole authored papers, and they get you know, academic credit and academic rewards for that. And you oftentimes simply just need a desk and maybe the internet to do that research or access to a library. Whereas if you're going to engage in data collection, it takes a bit more patience and it's more of a long trajectory, and you have to interface with others and the collaboration, and so it is a more protracted engagement. But you know, you learn over your career how to manage this, how to do multiple kinds of projects at the same time, how to have different phases of research come into fruition at different times, so that you're not always doing data collection, or you know, you've got some write-up going, some new proposals going in, and so on. And you would learn to deal with multiple issues and multiple problems. But that is a shift that would be required in order to do this kind of presentation. Okay. Any other questions about that aspect? Okay, I want to highlight some of the differences between types of psychology. You know, I think just the way that there are many sub-disciplines in law, and we realize that people specialize in many aspects of it. Psychology is very similar. And so there are many types of psychologists and many types of psychology. And some of the words and terminology can be a bit opaque to those who aren't initiated or members of that fraternity. So forensic psychology has, I mean, if you just look at what forensic means, it just means to do with the law. And that's in its broadest sense. However, in its use, the word forensic psychology tends to apply almost exclusively to clinical psychology in the law, and not to other types of psychology. And so many years ago, when I was president of the American Psychology Law Society, and I was worrying about the labels and terminology of our discipline in our field, I was trying to restrict forensic psychology to include many other types of psychology in addition to clinical, because there was so much else that was going on in the legal arena than just clinical psychology. However, my colleagues in that arena, you know, finally persuaded me that this was a lost battle and that forensic was going to be applied only to clinical, and it would be too uphill to try to reverse the associations that are already developed in the community. So there's a bit of a labeling disjuncture sometimes. So forensic psychology in different places sometimes means slightly different things. In Australia, and possibly in the United Kingdom, forensic psychology sometimes is used more broadly just to mean psychology and law. So what has happened because of all of this muddle with the terminology is that those who do non-clinical legal psychology work have shifted to that label of legal psychology to try to distinguish themselves from the clinicians. So I'll get back to some of these definitions, but I think you need to be alert to the fact that it's not always quite as simple as it seems in terms of the psychology arena. So I don't know if there are any of you here who have studied psychology, but you might be able to highlight for us some of the other sub-disciplines that we'll talk about as well. When I did a little bit of research, just trying to see what labels were used in India, it seemed to me that the word criminal psychology was the most prominent one used here for what probably I would call legal psychology. You know, so criminal psychologies, there are journals, there's at least one or two that I know of that use the word criminal psychology in their title, and you know, that's clearly very much focused only on crime and not civil endeavors, whereas legal psychology could be civil as well as criminal, you know, so it has that limitation. But I think at least it gets to the concept that we're not focused exclusively on clinical work. So it is helpful, and we'll come back to it, to unpack a little more what are some of the definitions of clinical, social, developmental, cognitive, and other types of psychology, and I will work on elaborating those momentarily. But at this point, I just wanted to give you a little bit of an overview of the intersection between legal psychology, which is what I consider myself to be, a legal psychologist, and empirical legal studies. And this is just an overview slide. I'm not going to go through all of these right now. We'll come to them in a moment. But we do need to understand a little more in depth what is meant by law and psychology as they intersect. We will focus on the applications or the outcomes and their limitations. We will focus on some of the methods that are used in this arena and different strengths and weaknesses that they have, and look a little bit at the types of expertise that is produced and the sorts of careers or roles that people have using those skills. And then I want you to take off and consider what can be done in terms of law and psychology or legal psychology or criminal psychology, as it might be labeled here in your country. Okay, how am I doing for time? Okay, good. All right, so I'm going to segue now into just a little bit more about the origins of empirical legal studies and the origins of law and psychology studies, so that you have a little bit of a historical overview of those developments. And these would need, if you're interested in these, you would need to, delve into their background more than I have time to do today. So I just sort of want to highlight some of the trajectory to show that, back in the 19th century, law was in fact really regarded as one of the sciences, so much more like natural science at that point, and has evolved since that day a little differently. And most of the labeling here is very American in origin, rather than British. But in the 20th century, and the very early part, there was a movement called the Progressives. And what they did, and this was sort of up until the time of the Depression, from maybe about 1890 till the Depression period, they were very interested in using law, to solve problems, and the efficiency of law to solve social problems. And so law was regarded very much then as an applied type of social science. Then from the 20s to the 30s, a period known as the legal realism phase took over, which is probably seen today by many scholars as the roots of empirical legal studies, which was focused much more on what works and how the law works in practice, rather than the black letter law in different treaties and books. And so that's very much a focus of empirical legal studies today, is to have an understanding of the actual functioning of the law and how it impacts the community. So we are sort of returning to that. From the 40s to the 60s, that was a period where legal process was very dominant in people's thinking about law. In other words, law was very much structural, imposing a structure on people. And during that period, with respect to other disciplines, the law would defer to their expertise. but legal rules that were policy-oriented and structural were the focus. Then later on in the 70s came the law and economics movement, where there was a lot of focus on assumptions that humans were rational and rational actors. And that what you had to do in the law was to provide incentives for people so that they would rationally respond to those incentives and therefore comply with the law. And what we learned over the years, is that people are not always rational in the sense that economists thought they were rational, that we don't follow pure Bayesian reasoning in our decision making, that we do other things, that we're very adaptive in our cognitions and our decisions, and so that model hasn't held up and been supported, though there are still law and economic scholars, of course, who participate in the empirical legal studies movement. In the 70s, critical legal studies was very dominant, and there was this acceptance of the notion that people who were legal actors, I'm calling them, whether they were judges or lawyers, but this is very strongly a reference to judges, that they took along with them all of their own personal biases and social biases and cultural biases in all of their decision making. Whereas more recently, the empirical legal scholar model has just been importing other methods of modern social science into the study of law, as we discussed a little or so ago. So that just gives you a little bit of a sense of what it is. But to talk a little bit more in detail about what people consider to fit straight into empirical legal studies would be some analyses of observed or experienced results. So this is, the notion of law being how it works and how it is experienced by the different participants. Dame Hazel Genn, who has worked for years at the London School of Economics and just is retired from her position there as dean, is one of the leading empirical legal scholars in the world, and did a great deal of work on defining the field and its attributes. And she said it was a study by direct methods of the operation and impact of the law. So that is a good working definition for you to take home and use. But I think what is most critical is to understand that we don't see ELS as a discipline itself, it's just an approach to another way or a lens to use in studying law and legal processes. But it does require you to have very distinctive types of questions and very distinctive types of methods to address them. And so figuring out what those boundaries are and how that might be useful or not useful is the challenge that's associated. And she commented as well, Dame Hazel did, that research that was done in the ELS mode was most typically focused on sort of purely legal questions that might come out of the doctrine. So very much driven by that sort of orientation. So in following up, that was expanded in the quotation I put there, saying, many legal and policy debates hinge on assumptions about the operation of the legal system. And that this sort of study encourages and promotes the careful, dispassionate testing of those assumptions. So many times we find that our legislators will pass laws with the assumption that certain compliance and outcomes will be guaranteed by the passage of those laws, and other things happen because those assumptions were incorrect. And I think you can probably generate examples from your own community of instances where laws have been implemented but have had ancillary effects or side effects that were just not anticipated or somehow impact a different group of people than those intended in different ways, maybe more harshly than anyone imagined that the law would, because those assumptions were not taken into consideration.
So would that not kind of push the entire area more towards a more realist kind of outlook? The moment you are going to start to work on evidence-based
or you are going and researching out things, and that comes back in what, I mean, you just can't deny. No, it's like realism, which is kind of evidence-based, necessarily push the legal discipline away from this, that, okay, whatever comes from the sovereign, so to say, or whatever comes from the state, is to be unquestionably seen as the law, and that's the only, you know, that in the sense of this very autopoietic way of operating within the legal system, wherein whatever change has to come from understandings within the law or within the system. Doesn't that get really majorly challenged by this kind of exercise?
I think it can, yes. Yes.
So then the point that is being made that it's not a disciplinary approach. I'm just wondering the sense of
how far it goes.
Yeah. I would certainly think that it more foundationally pushes you towards a perspective towards the law which is much more grounded in practice than we have ordinarily been trained to do.
I think that is one of the implications, and you know, and it's probably quite difficult at this stage to say exactly what those limits and boundaries might be. You know, but I think there is some growing scholarship assessing exactly those kinds of questions. But I think you are absolutely right that is the implementation. Yes. Okay. So you know, why do we bother? And so this, yes, your question.
With some of the authorities like APA or task force or generalist report and all.
In that case, it is developing. Empirical studies are developing in a developing stage. So any study which is having statistically analyzed and then tested and proved by the experts, panel of experts in a committee approved by a proper authority or an organization, that will definitely in future it will take proportions.
Right, and can you just explain to others which study you're referring to? It was an APA report?
Any kind of study, any kind of statistical studies, which is any between the group, within the group, or any experimental studies that are being taken up in a couple of, after a couple of these, that is being proved, tested statistically later, will become empirical.
Sure. You know, so the question I think that follows from that is that we need to know more about how to assess and evaluate the strength of empirical studies, and we need to have some criteria that are developed about when they are adequate as a basis for reform. You know, because you know, statistics vary in their strength and their quality, and you may want to have much more validation of an issue if it's a very serious issue that is going to be changing dramatically directions in the law. So more robust data might be needed.
Yes, but I think it needs a lot of interdisciplinary approach.
Yes, and you know, of course, you know, in the fields of science, there are traditions for assessment and evaluation of research that have developed. You know, and part of it includes the peer review process. Part of it, you know, even peer reviews, of course, for research grants that are funded, and then special committees or commissions to try to assess the outputs. You know, and a good example, I think, some of that work has been done by the National Academy of Science in the United States recently, looking at the quality of forensic scientific research that is done in many areas, you know, such as footprint studies, you know, fingerprint studies, handwriting studies, voice analyses,
neuropsychology.
And neuropsychology, of course, too. You know, neuropsychology is particularly interesting because it has the allure of giving you these sort of concrete pictures of the brain, but what does it mean, you know, and what inferences should you really draw from some of those pictures, and what expertise do you need to change decision-making on the basis of those outcomes. And so, especially some of the fresh and innovative new sciences and neuroscience has been growing at a dramatic pace in the last decade, that, you know, fall into that category. So it's being used in very unanticipated ways, and constantly new ways, you know, and really is a growth industry.
Changing according to the technology, right?
Absolutely, absolutely. Technology is, you know, changing the way many things are done in scientific arenas. Okay, so to look a little further at why this might be helpful or significant for lawyers is, you know, the notion of global interest in what works in law, and people learning from one legal system to another. So there's a very strong comparative component that underpins a lot of empirical legal studies and that community. The notions that because legislation or regulations exist within one particular social context, they're going to be crucial to contemporary social issues. Whether it's migration, whether it's marriage, where, you know, there are a host of things that impact all of our daily lives that come from various regulations. The point that we're talking about, the necessity to evaluate all of those different aspects of it. And I've highlighted the point about avoiding speculation as a basis for policy decisions. And also the notion that there's so much growth in legislation in all different aspects of life. I mean, if you deal in workplace law, for example, and you're a manager, and you're you know, or dealing with corporations, you're constantly having to get on top of new legislation that affects how the workplace and companies are regulated, and it's you know, very difficult to stay on top of it because it's constantly evolving and more demands are made. So because there's so much regulation and it's proliferating, the notion of sorting out what is effective and what isn't in this sort of way can be done. What are some of the resources or some of the indicators of the growth of ELS? One of them is the foundation of the Journal of Empirical Legal Studies and the Society of Empirical Legal Studies along with it. So if you subscribe to the journal, you de facto become a member of SELS, or the Society for Empirical Legal Studies. And I think my statistics here are probably a bit out of date, but the point I'm making here is that this journal was launched relatively recently. Among refereed law and social science journals, its ranking is top. It's #1. But of all journals, it does pretty good in the USA, and probably better than that number. And who are they? Well, you know, it's an international organization of scholars who are interested in this topic. And what are they about? If you look on their website, which you should do, you'll see that they want to work with all of these multiple disciplines. They have an annual conference where there are posters that people present as well as oral presentations, and those some of them land up in the journal after peer review, those writings. And it's just to encourage and provide a forum for scholars we're doing mostly experimental work on legal issues, but some qualitative work as well. And it is a repository of primary data about empirical legal work more than anything else. But you know, they're very clear that their goal is to cut across boundaries in terms of locale or geography. What are the kinds of methods that empirical legal scholars use? We've touched on that a little bit, but I've just highlighted a list here. You know, so surveys are common, interviews very common, impact studies, definitely experiments of different sorts, citation counts, program evaluations would all be part of that. And from the statistical end of it, that we've talked about a little, you know, you can start out with simple frequencies or percentages, proportions, but go on to do what are called inferential statistics, where you make a statement that something, you know, is unlikely to have occurred by chance alone, because you've tested it in a certain way. And, you know, there's just a host of different kinds of tests that you can use statistically, depending on the question that you have. And so those would vary. I've tried to summarize a little bit what some people have said are some of the advantages or disadvantages of this kind of approach here, but these are really just sort of seeds of ideas, and we've probably, I think, alluded to them a little bit. I think it's important to emphasize here. You know, I think if we look at the bottom of the list there, you know, that maybe law is seen as dealing very much more with moral questions that can't necessarily be answered by science. Psychologists might quibble with that quite a bit and think that they are capable of developing methods to look at moral issues and moral questions if you approach them the right way. You know, and you know, certainly that your inferences have to be constrained by the context of your data. Every study is limited. We learned that, you know, every study had most research reports finish with a section that describes the limitations of the study. It's a mandatory part of reporting on research. No study is perfect. They all can only do so much. And so you need to understand what are those constraints of your empirical data collection, whether it's your participant pool, who fronted up for interviews or responded to a survey, and why, and who was discouraged from participating inadvertently perhaps, etc. All of those things can affect the strength of the inferences that you draw from your data. You know, but nonetheless, you know, they might advance the responses to those theoretical questions.
I had this one worry, Jane, in the pros and cons. Considering, like you said, one dimension that you spoke about was the moral issue, but just the fact of the ethics of the research, you know, in the sense of sometimes the kind of people you're researching are not in a situation to maybe refuse. Sometimes you find that people say what is expected, and especially in this kind of scenario, and what your interplay with the law has been, could possibly be just your own subjective interpretation. So if this is going to be evidence-based to feed into policy or to feed into how we should be doing or formulating law, don't you think there are parts where we're really skating on thin ice?
I think those are very important critiques, but I think that most experimental methodologists have worked quite assiduously to try to address ways to get around those problems. So, for example, on the issue of, do people just say what you want, what they think you want them to say, give you what you want to hear, rather than frank, honest opinions about a topic? You can use methodologies in psychology where you include certain questions in a survey, which are designed to indicate to you whether people have a likelihood to exaggerate or a likelihood, in fact, to fabricate. And by including those items, you can then figure out maybe what proportion you need to discount. Certainly, if you're doing interviews where the demand characteristics and the social compliance might be much stronger than in an anonymous survey, there might be ways to run that to try to minimize it. The recruiting issues, you know, all of those issues become very, very important to try to get higher quality data. So mostly, if you become acquainted with a method that you think is going to address an issue, and look at how people have addressed those rigidities of it, you will find that there are ways to address it to run an ethical research study that hopefully gets around it. I mean, the best way to get around it is to do what we call to be a randomized controlled experiment, where half the people who are participating have no idea what, you know, what the control, that they're the control participants for others, and then you compare their responses with those who are exposed to a special treatment. And if you randomly assign people to the different conditions, then you wash out those kinds of demand characteristics just by virtue of the way that you collect the data. So that's considered to be the gold standard approach to deal with those sorts of biases. And it's quite hard to do, and sometimes it means, you know, you have to have extra cells or conditions in your study that are there for the control purpose. But if you do go through the trouble of collecting those data for the control groups, you have a much more powerful basis to draw the inferences about the results that you get. So the payoff is great. You know, so criminologists have and sociologists have worked very hard in the criminal arena to try to figure out how to do randomized controlled studies. And in Queensland, Australia, for example, there was a program that was implemented just with random breath testing that is done with police officers stopping cars, to try to look at the impact of procedural justice variables that changed the way that the random breath test was done. And they just did a fully randomized controlled study because they planned to take into account those threats to the validity of the outcome, and produced really fascinating results. You know, so one of the things that we'll talk about is the necessity of not just rushing out and getting the data, but planning from the outset the way to include those controls so that you address precisely those kinds of issues. Yes, because otherwise it would just be opinion in a different shape or form and not get beyond the obstacle that we're trying to avoid. Okay, so turning now just to the psychology and law focus within ELS, and why psychology seems to have a good contribution to make in this arena compared to some of the other disciplines, is because psychology itself, does focus on human behavior as well as the mental processes, and attempts to understand and predict human behavior, so that's really important. If the law is making assumptions about how different policies and legislation will change behavior, or produce compliance, or reduce crime. Different parts of psychology do this in different ways. So here's where I wanted to talk just a little bit further about those sub-disciplines. So clinical psychology, which is what you encounter most in the legal system, really is what we call mostly abnormal psychology. So you're dealing with individuals and aberrations from the norm most of the time if you're a specialist in clinical work. And you might provide therapy, or you might provide assessment, or you might do research on it, but more than anything else, you're going to be focusing on things that vary from the norm. And I'm not interested in the non-normative as much as I'm interested in the normative. So I never studied clinical psychology when I did psychology because in the United States where I did my psych work, you chose between clinical or non-clinical kinds of focus, and my focus was more on learning and cognitive psychology, or the mental processes that were normative. How do normal people behave and respond and think about things. And social psychology, too, is a normative discipline in psychology, but focuses much more on the group effect than the cognitive psychologist who might focus on individuals rather than groups or the group process. So social psychology and cognitive, and I sort of tend to work myself between individual and group phenomena, certainly have a different orientation. It's very key to the law. And then if you work with children or adolescents or the trajectory from infancy to adulthood, then you do what is called developmental psychology. And you're interested in normative processes again in terms of how people grow over the years and what you might reasonably expect of them at different stages and phases. The neuropsychology we've touched on already as an expanding new focus in psychology, underpinned by a lot of physiological data gathered in different ways. And similarly, those are just examples of all the ways that the law is broken down. So the notion with psychology, though, is that it should also interface with other disciplines in the law and psych movement in order to achieve what we think is transdisciplinary. And you've probably heard of interdisciplinary, multi-disciplinary. You may not really yet have encountered the phrase transdisciplinary. So I wanted to take a moment just to expand on what I mean by that. And there's another slide on that. And let's jump to that. Not a very difficult definition at the moment. But in essence, transdisciplinary goes far beyond just collaborating with someone else, to do the quantitative components of your research. It is sharing more of an understanding about the solutions rather than just an understanding of the problem. It's participating jointly on generating ways to address solutions with other disciplines that incorporate the strengths of all of those disciplines. Whereas I think interdisciplinary work on its own tends to just have a shared understanding of a problem, but not necessarily engage in the resolution or the study of it in the same way. So legal psychology or law and psychology does far more than just apply clinical psychology to criminal law. And we've talked a little bit about the way it can be broken down into subdisciplines. Sometimes people chop it up by looking at the theories that are associated with it and whether they generalize across the different subdisciplines. Sometimes they divide it by the applications or the populations. Are you interested in studying juveniles? Are you interested in studying the elderly? Are you interested, in some particular subpopulation in psychology, inmates in a prison, for example, taxpayers, etc., might become your population. And so, what I wanted to do is just give you a clear definition of legal psychology. It comes from one of my colleagues, Jim O'Rourke, as the scientific study of the effect of law on people and the effect that people have on the law in turn. It includes the application of the study and practice of psychology to legal institutions and people who come into contact with the law. And legal psychologists evaluate the assumptions that law must make about human behavior, as well as the way in which the law responds to changes in society that require changes to the law. So the notion that there is this dynamic with the law changing in response to society, as well as the interface with people, are the core features. And it really has as its goal to produce knowledge and methods to tasks that are faced in the criminal and the civil justice systems, and to improve their decision-making, their outcomes, whether it's in a law office or a courtroom or some other legal setting, such as a legislature. So what I thought I would do right now is ask you to take a look at a case problem and see if you can identify some psycho-legal issues based on your knowledge of the law or your own discipline and orientation. And so I'd like you to read through these case facts, then we're going to take a break, and then we'll come back and just pull together in a sort of a group discussion. We'll give you a chance even to talk with each other a little bit about it. Some of the issues that might be lurking in this case. This is a real case that arose in Australia and Queensland, where a mother who was in fact a qualified registered childcare worker, about age 35 at the time of these events. She had one daughter who was about 7 years old, and then she had 3 male triplets, all with the same partner, but the relationship had fallen apart and had been on and off for a number of years, but had dissembled by this stage. Her triplets were born quite premature, and she had been at home 3 weeks, but the triplets were 8 weeks old when these events occurred. The father wasn't living with her anymore, he was elsewhere. So on this morning, she got up at 6:30 a.m. To get the family ready so she could take her 7-year-old daughter to school. She put the triplets in their rockers that were all matching, fed them, and then dashed into the shower and left her 7-year-old out to watch the triplets. And then after her shower, she started to put her babies into the car so she could drive her daughter to school, and she noticed that one of the triplets was not breathing. So she called a neighbor for help, then called an ambulance, and they arrived and declared the baby dead. What happened that was contextually important is that you know that the daughter, who was 7, was 42 kilograms in weight and about 135 centimeters tall. She was asked whether she had seen anything going on with the triplets or touched any of them. She said she had changed the baby who was deceased while her mother was in the shower, and that she heard him make a funny noise, but she didn't pick him up afterwards because he fell asleep soon after that. She said that he had fallen out of his rocker 3 times the day before, but she had never picked him up or dropped him. When there was a post-mortem examination of the triplet who died, there were no external bruises at all on his body. There were internal bruises in the scalp area on the top, and those were fresh. At least 12 hours before the death, there were skull fractures, as if from quite severe force. The mother, at the time, admitted that she was exhausted and tired with the 3 triplets and the daughter that she was caring for herself. She was on pain medication because she still had some stitches from the cesarean. And the surviving 2 triplets also had evidence of bodily injuries fairly similar to that of the triplet who died. Okay, so those are the critical key facts, and the issues for you to think about during the break, and maybe to discuss a little bit in groups afterwards, are how many psycholegal kinds of issues or empirical questions can you find looking at this if you were dealing with this case, whether in an investigation or in court or in adjudication. What would be the kinds of empirical data that would assist you in determining what happened and whether the mother should be charged, or if she is charged, what might happen to her? Okay, any questions about that? No, okay, break time.